Hello everyone, this is Gautam from Shailaja IAS. The issue that we'll be discussing here is about your POCSO Act and the weaponization of it. Now, why it was in news? Because in January 2026, Supreme Court in one of its cases has formally acknowledged that the act is being misused or the act is being weaponized. Weaponized in the sense you're trying to use the existing provisions to hurt someone. Okay, by you can say misusing all the vulnerabilities or the loopholes that are present in the act. Some of the cases are misusing such provisions in the act. So we'll try and see what is the Supreme Court's observation later, but first we'll try and understand what is the brief background of this POCSO Act, that is Prevention of Children from Sexual Offences Act, which was passed in the year 2012. I will try and understand what are the structural vulnerabilities that are present in the Act, in the sense what are the loopholes which are being exploited by other people, especially by the powerful people. Third, we'll be understanding the consequences of these vulnerabilities, consequences of the misuse of these provisions. And we'll understand what has been the government's position and why government is taking a certain stance consistently across the cases in Supreme Court or in High Courts, whereby it is refusing to, change its position. We'll try and understand the government's position and why it is doing so. And finally, we will see what has been the Supreme Court's observation or the intervention in this particular case and what more measures needs to be taken. Right. First and foremost, the POCSO Act, as I told you, was enacted in the year 2012. The reason was very simple. They said that whatever are the existing laws that our country was having at that particular period of time, they were not sufficient enough to deal with the peculiar cases of child sexual abuse. Right. So, country, unfortunately, this this evil has been there since the ages. I think I must also share that I have personally experienced in our neighborhood where a 60-year-old man was sexually abusing a 6-year-old girl, and one of my students caught red-handed, and we then took it to the police case, and we went through the normal legal procedures of filing this POCSO Act. So I have more or less a first-hand experience of how this legislation is actually working, and also the social reality. Yeah, so it is really painful and hurtful. Really painful to see a 6-year kid. Younger than his granddaughter. He was also having a granddaughter. Younger than her, he was trying to sexually molest her. Now, since such dark realities are also present amongst the society, we need a stricter legislations. So it was in this context, because of activists and because of various movements, the government felt that there needs to be a specific legislation to deal with this menace, right? And it has certain strict provisions with regard to the punishment, with regard to filing of the reports, with regard to accountability at the police level. Because I personally saw that how the police staff were also very serious when such cases enter their police station limits, right? Now, the first and foremost thing is that there is a mandatory minimum punishment of 3 years, and it can extend till your life imprisonment. So, depending upon the severity of the crime, they can extend it till life imprisonment, but minimum sentencing of 3 years is there. And there is a strict liability with regard to mandatory disclosure of such incidents. If a teacher or a school staff or a doctor or any other important positions people, they are come to know about such incidences, they are mandatorily supposed to inform the police. So such strict provisions are there, strict punishment is there, and it's a gender neutral legislation in the sense it is not only dealing with sexual abuse for girl childs, which is rampant, it is also equally applicable or protecting or providing the same sort of safeguards for the boy child as well, who are also equally vulnerable to your sexual abuse. Now, one of the loopholes or the structural vulnerabilities in this act is the blanket definition of a child. A child is defined as someone who is less than 18 years of age. Now, what is the problem with that? That's an international convention. Even the rights on the child clearly specifies that a child is one who is below 18 years of age. All the international conventions designate this number for labeling a person as a child or an adult. Now, what is the problem that arises with this particular definition is your adolescence time period. That is your age 14, 15, 16 and 18. Generally, you are in your high school, your hormones are changing, and you try to explore certain intimate relationships, especially in the age group of 16 to 18 years. Uh, People tend to have romantic relationships with the opposite sex. They tend to explore, it's a normal thing, right? Any 16-year-old or a 17-year-old or an 18-year-old person would tend to have a boyfriend or a girlfriend and tend to have some intimate physical relationship, especially in the current age. Now, according to, if it is a consensual thing, if both the boy and the girl are consenting to that particular romantic relationship, even then this particular act sees any sexual abuse as a crime. So if a girl is being kissed by her boyfriend with her own consent, but the law does not take into consideration. The law says that this can be termed as a sexual abuse. So this loophole is now being misused by in certain instances. Now, where do we see the misuse? For example, a girl child is dating a person from another caste or another religion, which is not to the liking of the parents. And they have come to know that they are in a physically romantic, intimate relationship. And they can immediately file a case in the police station stating that the boy is sexually abusing her. And because of the stringent provisions in the act, the police has to compulsorily register the act, and the boy is placed in the accused position. Okay, he will be arrested, he has to fight for bail, he has to prove his innocence. So in a sense, this provision, where the law is very strict, is being misused, especially in instances where the parents are not agreeing with the relationship of their children. Okay, and that is what is the fulcrum of the Supreme Court judgment. They say that we need to clearly distinguish between a genuine romantic relationship versus a predatory relationship. Predatory in the sense which is exploitative in nature, which is trying to abuse the child. So that distinction is somewhere missing in this particular provisions of the act itself, because there's a blanket definition of an act, and any sexual act is considered as a crime irrespective of the consent. So even if both the parties are consenting to a sexual act, it is considered as a crime. See, this is a tricky issue, okay, because this is a tricky issue. There might be a genuine cases where a child may not be having the maturity to understand if it's a really romantic relationship or if it's a exploitative predatory relationship, because we have often come across incidents or stories where a girl child who is adolescent, who is vulnerable, whose hormones are in a confusing state, they tend to get attracted to people generally much older than them, and these older people try to exploit this vulnerable situation. We have seen stories where a 25 or 26 or a 30-year-old man trying to exploit the vulnerability of a 16 or a 17-year-old girl child, trying to engage initially in a romantic relationship and then try to exploit her, try to sexually exploit her, try to blackmail her by filming certain videos. And this is clear-cut case of criminal offense. Okay, so the law is intended to deter or tackle such kind of predatory, exploitative instances. But at the same time, we also see certain cases where a 16-year-old or a 17-year-old girl is genuinely in relationship with a 19-year or a 20-year-old boy who is a senior, and if at all they engage in any, can say, sexual activities, it is considered as crime irrespective of the consent as per the provisions of this law. Okay, so the law was designed to protect or to prevent, you can say, instances of sexual abuse and have tougher punishment criteria. But since there is a blanket definition, it is also being misused by certain people, right? So another important structural vulnerability or the loophole over here is the burden of proof is on the accused. Once a girl child father files a complaint that this boy is sexually harassing my daughter, and you're supposed to arrest that person and put him in jail as per the provisions of the law. Now, according to the law, he is considered as committing a crime, and he has to prove that he has not committed a crime. Generally, it is the opposite. In other crimes, the prosecution or whoever is filing the case has to prove that the opposite person has committed a crime. It is assumed that the person is innocent till proven guilty. It is opposite in this case. Here, the burden of proof is on the accused person. So the boy has to prove that he was not engaged in a predatory or exploitative sexual act. Okay. Next, as I told you, the where it is being misused is by families, especially in your inter-caste, inter-religion, or inter-class. Okay, so people who are very well aware about the provisions of the law misuse these provisions in order to control their child. Okay, so that is very clear. Next, now what are the consequences of this misuse? See, obviously, it's going to criminalize your normal activities. See, during adolescent time period, exploring relationships or exploring opposite gender is normal. And if such provisions are applied without any distinction between a genuine thing or a exploitative thing, it is certainly going to impact, or it is certainly going to criminalize the normal activity itself. Suppose in a college where there are 1,000 students, if there is one case of like this where the person has misused this provision in order to put a boy behind the bars, obviously that incident is not only impacting that particular couple or family. The entire college will come to know about this, and there will be a lot of people who would be impacted by such and such an event. Especially in college time period, any small event is going to become a big scandal, right? So if such cases are being filed against, you can say, genuine innocent students who are genuinely exploring a romantic relationship, it is going to criminalize your normal activities itself. So even other students or other people tend to, you can say, restrict themselves with regard to forming any relationships, right? And it's also going to create a psychological impact on the couples itself, both on the boy as well as on the girl, because they are coming under the pressure of their parents, and parents or under the legal system itself. So legal system is also very blind with regard to this provision, because they clearly say, it is written in the law that any child under 18 years is, any person under 18 years is considered as a child. If there is a sexual activity, it is considered as a crime. So that legal strictness, and judiciary also does not have much of a leeway. Judiciary has to implement the law that has been made by the legislature. So judiciary also says that I am bound by the legislation that has been passed by the parliament. Okay, so this issue was time and again arising in various high courts, your Madras High Court, your Karnataka High Court, your Kolkata High Court. All of these courts in various other cases had felt this particular dilemma, whether to strictly apply the law as given in the legislation as passed by the parliament, or to verify the case for its genuineness and try and give some sort of a leeway. But now this entire thing has gone to the Supreme Court, and Supreme Court has clearly cut shade. It has formally acknowledged, yes, the legislation has been misused, and it has clearly said that it has to be decided on a case-to-case basis, where you have to understand the nuances of a case. You should not apply the legislation blindly. So that approval has been given by the Supreme Court itself, right? Now, I think we rushed too much into the future. The consequences of it is what? Obviously, if people are misusing it, it is going to criminalize your normal activity. It is going to create your psychological impact on the couple, and also their, I can say, surrounding the students or the friends. And most probably, most of these couples tend to live in isolation. So they don't want to face all these things, and they tend to isolate themselves unnecessarily. That is the age we are supposed to explore, but you are coming under your legal restrictions. And apart from all these things, systematically also it is creating unnecessary cases in the court. Okay, so there is overburdening of the courts, and some of the crucial resources of the courts is being drained towards filing these cases, frivolous cases. Okay, and there is a re-victimization of girl. Okay, so whereby even if a girl has consented to the activity, she is forced due to the patriarchal system to testify against her boyfriend in the court. So as a result, the patriarchy is going to be further entrenched. Okay, so these are all some of the consequences of misusing your vulnerabilities. Now, what has been the government's position throughout all these cases? It is not like government was not aware about this. In every case, the government is a party to it, and they have to argue: should we lower the age of 18 years to 16 years, or should we bring it down to 17 years? So there is always this, you can say, debate that is happening whether we have to keep the age fixed at your 18 years. Government has been very clear, and its law commission report has also clearly said that it opposed lowering the age to 16 in various Supreme Court proceedings, in various High Court proceedings. It has clearly said we have to keep at 18 years itself. Now, why the government is taking this stance, or why the government is telling that we can lower the age to 16, why government is not agreeing to that? First thing, the argument they say is that they will not be having cognitive maturity. A 16-year-old kid will not understand the consequences of the sexual activity which he may engage in, because it will all be passionately driven. Whatever activity is happening, even though it is happening with a consent, she will not be having the maturity to understand the consequences of it. Okay, so they say that it is better to keep it at 18 years itself. Third, they say that having a higher threshold of 18 years will help the government fight against trafficking. Okay, so trafficking in the sense, what do you mean by trafficking? Where people are taken out of their homes and put into your brothels or for prostitution, or they are sold to other parties. This is a huge social menace. It's difficult to, you can say, fathom, or difficult to realize that such cruel activities are happening in the world. But unfortunately, these are happening, and government needs to take certain measures to tackle with it. So they say that if lower the age to 16, there are high chances that people under the garb of consent are going to misuse the girls and send them into trafficking or the prostitution part of it. Okay, so they also say that it's they are bound by international conventions. Your international conventions strictly define the age of a child as those belonging below 18 years. So government of India clearly states that I have to follow the international convention, so I cannot lower the age to 16 years. Now, what the Law Commission has instead recommended in 2023 report is your guided judicial discretion. The Law Commission has clearly said, see, legislations we cannot bring it down to 16 years, but there can be a guided judicial discretion. In the sense, judiciary can take a discretion, but it should be guided. Whatever discretion it is taken in case by case, it can maybe not apply strict provisions of this POCSO Act. It can clearly say this was misused, so you can dismiss the case itself. Or if there was some element of exploitation, you can give a less severe punishment. So that discretion should be allowed for the judiciary depending on case to case, and it should be all guided. So these are the positions of your Government of India, supported by your Law Commission reports. As I told you earlier, with all this debate, all this, I can say, reports, all these controversies, Supreme Court finally said that it has formally acknowledged that the weaponization of POCSO Act is happening, and it says that we have to go for differentiation, whereby there is a consensual, you can say, activity versus a predatory or an exploitative activity. And it says that judiciary has to, you can say, take a discretion with regard to these two things, and it is also given certain guidelines to the police on how to deal with these matters. So it says that the police has to first verify the authenticity of the complaint itself before strictly register it under the Act, right? So these are some of the outcomes of the Supreme Court judgment, right? And it has also clearly said, or it has given an advice to the government that you please pass a legislation whereby there is a legislative backing to the guided judicial discretion. In a sense, judiciary can always say that, okay, such a provision was present in the legislation whereby 16 to 18 years, if there is a consensual romantic relationship happening, you cannot file a stringent case. So if that discretion is allowed by the legislation itself, it will be better in terms of law. Okay, so that is what Supreme Court has given in this particular case. Right. So what more needs to be done? It is not just that we are having Supreme Court judgments or we pass a law and suddenly the society is going to change. No. there has to be certain institutional changes, there has to be some social changes in order to tackle this entire menace. The first and foremost thing is that you need to go for preliminary inquiry requirement. Make an initial check before actually filing the case. That was one of the guidelines given by the Supreme Court to the polices. There has to be a legislative amendment, as the Supreme Court has given the guidelines that you please change the legislation whereby you provide this Romeo-Juliet clause. Romeo-Juliet clause is nothing but 16 to 18 years. If there is a consensual activity, then they are immune from this particular act or legislation itself. There has to be a special review committee whereby they review the FIRs within 24 hours and recommend if the case actually warrants a POCSO legislation or not. Right? So they are saying they are putting in certain layers. So these institutional mechanisms will prevent misuse of this POCSO Act. Right? Also, there has to be mandatory education in the education itself, education institutions itself. If the students are made aware about the provisions of the Act, if the students are given sex education, they will be more careful with regard to engaging with each other. Right? And we have to have some legal aid and relationship counseling centers in the districts whereby affected couple or affected people can go to the centers and seek support from these particular centers, be it with regard to fighting legal cases or be it with regard to counseling or mental trauma or rehabilitation part of it. And finally, every year, government has to conduct some sort of a audit report on how many cases were filed under the provisions of POCSO, how many were convicted, how many were misused. If there is a thorough audit report, obviously it is going to get transparency with regard to the functioning or the implementation of this legislation itself, and we can take corrective actions. So this is all about the issue. I hope you have got a clear-cut idea. This is not really like it's important from an examination question and answer perspective, but it's important to understand the reality of the legislations and where the legislations are being misused. So you can just quote it as an example in any of your ethics answer where legislations are misused by people itself. Or you can quote it in your governance answers where you can say that effectiveness of legislations is being eroded due to misuse of its provisions by vested interest. As an example, if you ask me, will there be an elaborate question on this particular issue itself? I don't think so, because they're not going to go into so much details of trying to understand the misuse or the weaponization of POCSO Act. But you should be aware about the workings of the Act so that you can use it as an examples in your either ethics answer or in your governance or society answers. Okay. So if you still have any doubt, you can directly reach out to me on my WhatsApp number or you can drop me a mail.